Good evening, Town Council, good citizens of Burrillville. I do have, Frank Silva, 1478 Warm Lake Road. I have a couple of communications to get across. One is from John Scott from Warm Lake Road. He's not able to be here tonight, so he asked me if I could read this letter. And it's I, John Scott, as a resident of Burrillville, believe that all tax treaty negotiations regarding the proposed energy power plant should be held with the incoming town council, not the current town council, due to the fact that the incoming council will be the ones mainly dealing with the proposed power plant if approved. John Anthony Scott. Okay, on the second draft I have here, memorandum from Barry Craig, 180 Moron Road, Pasco. Unfortunately, Barry couldn't be here tonight. Barry's down in Tennessee, so he asked me if I could take a ride by the town hall and drop a copy off to Louise so she could distribute this memo to the council. So I'll go forward with reading it. And it's in reference to the final draft proposal tax agreement. By memorandum dated October 10, 2016, I offered you my views on the agreement. In your deliberations tonight, I hope you'll take those views into consideration. I raised one question in that memorandum, however, that is deserving of some elaboration. Namely, whether the town council has the legal authority to enter the agreement at this time. This memorandum elaborates on that point with the same disclaimers I offered in the October 10th memorandum, namely that I am raising the questions to be addressed by the Rhode Island Council, and I'm not expressing opinions on Rhode Island law.
Hey Frank, I need you to be quick, okay?
Okay. The tax agreements rely on section 44.330 of the Rhode Island statutes. So you do have the statutes, so I won't get into that part of it. The question I raise is whether the agreement meets the requirement that is subject to be property used in connection with a facility for the generation of electricity. The statute says used, not to be used, and the property is not even owned, much less used by Clear River Energy LLC. Moreover, Clear River has not even applied to the EFSB for a permit to use the property for the generation of electricity at some future date. In addition, the agreement deals with payments to be made prior to any use. Unless there is a governing judicial precedent to the contrary, the statute that the town proposes to rely upon does not appear to provide the town with the legal authority the town needs in order to sign the agreement. The second question I raised relates to the representation contained in the agreement. The town represents there are no actions, suits, or proceedings pending, or to the town's best knowledge, threatened against or affecting the town before any court, administrative body, or tribunal that might materially and adversely affect the ability of the town to perform its obligations under the agreement. The representation is simply incorrect, putting the town in default the moment it signs the agreement. There is no quick fix. The council is obligated to present the final drafts to the public for discussion prior to the execution. Any modification in this representation requires the council to publish the draft again. If the council does not believe my October 10th comments have sufficient merit to cause the agreement to be revised, I nonetheless urge the council not to proceed to authorize execution of the agreement without first obtaining comfort that the town has the legal authority to sign the agreement. At this point, it is reasonable to assume that the agreement, if signed, will become the subject matter of litigation both in the courts and before the EFSB. In the case of courts, it may be that members of the council will find themselves defendants, as well as the town, with little patience. The town, with the advice of its council, may be able to take the following steps to assure the town is acting legally. A, if available under Rhode Island law, seek a declaratory judgment that the town has the authority to enter into the agreement.
Frank, can I have that copy and maybe give it to Mike McElroy and let him review it?
Sure, we provided the copies.
Okay.
I'm almost done.
Okay.
B, while less in the way of comfort, obtain an unqualified opinion of council that the town has the authority to enter into the agreement to provide the necessary credibility of such an opinion. The council should be a Rhode Island lawyer, otherwise independent of the town, experienced in statutory construction. In fact, the town appears to have taken this course of action with Ocean State Power. The original 1988 tax agreement recites that an opinion of bond counsel was sought and obtained. C, ask the EFSB to condition the issuance of a permit on the town and the ultimate generator of electricity to enter into a tax agreement. That's it.
Okay. Thank you, sir.
Okay, I got one more for me. So I know I'm over the 2 minutes, so give me a break. I'm sure there's going to be a few more people that are going to renege their
There's a lot of
position.
names on this list, man. We really gotta...
Okay, I'll be quick. Now, the property value agreement, I disagree with. First and foremost, I do live approximately 3/4 of a mile from the plant. I'm a butter to the power line as well. And the section of the power line is only 300 feet wide, and it expands to 500 feet, maybe 1,500 feet beyond my house, heading in the other direction towards Connecticut, the same thing, it opens back up. For some reason, it bottlenecks right there. And they want to put a third line in. There's actually room for just 2, and there's a decent buffer. I'm not in the right-of-way, I'm just a butter to it. And it's going to be a really big eyesore, increase in electrical, magnetic field. It's a real big problem. And there's 3, 6, or 7 houses in that approximate area or more. No one's been up there to check it out. I've been to Mike Wood's office. I sent out an email today to address that issue. But there's more than that, okay? In that property list, there are houses a mile or more, up to 1.5 miles away. I would think that I had geometry right here in Burrillville High School, and I know what a radius is, okay? And if it's 1.5 miles of the furthest house, then I would think that we're going to be taking in a lot more houses, like maybe Round Lake City, which I just can't believe that there isn't a single house in Round Lake City on that list. And that's a pretty condensed neighborhood. There's quite a few homes up there, and they are very close to the plant. I lived on Doe Crossing Drive. I grew up there, as well as many friends from Wilson Drive, and it's really disheartening to see, considering that they're uphill as well. The elevation increases more than 100 feet or more, and LNG travels, it's light in the air. All right, so going back further, now, I have a personal experience with Long Lake Energy. And Long Lake Energy was a plant that I'm not sure that any of the council members would be familiar with, but maybe some, such as Council Nancy Binns. But Long Lake Energy wanted to put in a power plant on Warm Lake Road, directly across my driveway. I was building my house at the time. I didn't like it. I was upset about it. There wasn't a lot of opposition that I could see at the time. Well, Susan Daycock was the manager, the front person for the whole project. She approached my home as well as the homes around there, the Costellos and what have you, and they did give us a property value agreement, and it was fair. It gave us comfort. It gave us the opportunity to get our own appraisal. They would get their appraisal. If we didn't come to an agreement, then we agreed on a third appraiser, a neutral appraiser, and we came up with the right number. There was no real estate fees. There would be no real estate transaction. They would assume the property when you're ready, and you would have up to 7 years. So now, when the time would come, you don't pay no 5% commission or 6% commission, no transaction fees. And in addition to that fair market value, you were given for the inconvenience of 15% on top of that value. So it made it easier for the homeowners around there, the stress that you were going through. This property value agreement is nothing in comparison. It really does put the homeowner stressed out even further. It's 165 days on the market, which is insane. It's very difficult for a person who says, hey, I'm tired, I want to throw in the shirt and get out of here. Now they have to hang for a while longer, and knowing that they're going to have to pay a commission fee and all these other expenses. You know, you have to realize, I've been living in this town for 43 plus years. Many residents here have been here for generations. We built this town, whether through mill workers or worked in the lumber industry or whatever it may be. They built this town the way it is right now. And then we're going to turn around and give a tax agreement to a company that has nothing to do with our town. And they're going to come in and they're going to reap all the benefits because we have a gas line and a power line that comes through here. So I ask that you don't go into this agreement at this time, to make it a condition of the permit in the event that the siting board does allow this plant to be built here, and make it a condition of that. That's the least to do. If we give them, if we hand them a tax agreement at this time, I don't care what the dollar value, if it's going to be $3 million in our pocket, I'd rather have my taxes raised to fight them than to get $3 million from people that don't really give a damn about us. We built this town. This is our town. Thank you.